day 13 of the Kouri Richins trial. So this turns out to be the last day. We finished up with the lead investigator, and I mean, the redirect did help where he said, yeah, we had to outsource a lot of our stuff because we're a small sheriff's office. We just don't have the tools available to us. We have to go elsewhere, which is fine that he doesn't understand the processes, doesn't have access to processes, but he should have better known the results of those processes, especially because he was in court every day and got to hear them. He could have taken notes and refreshed his recollection at any time. Now, of course, the defense always likes to play the we're going to ask the wrong person the information to make you look less competent game, but still. The prosecution rested their case, and so did the defense. They hemmed and hawed and put on some theatrics for about 40 minutes before they were like, we're going to rest our case. Meaning they didn't bring one. They called no witnesses, no experts, and Kouri did not get on the stand as the defendant. Every high-profile case that I've ever watched, they're always like, the defendant's going to take the stand. And I never believe it, and neither should you until you see their butt in the witness chair. And that's very common, and it is the most brilliant thing that this defense team has brought forth. They have had good point outs, but it got muddied, which is their whole strategy, is leave the jury confused, make them wait so that they distance themselves from the information, just getting annoyed sitting around waiting. And it's Kouri's right to not be cross-examined, and they don't want any of their witnesses cross-examined. And I don't care what they tried to say, they knew that they weren't going to bring a case from the beginning. My evidence for this strategy is that they had 5 witnesses who they were, I mean, out of 45, it doesn't sound like a lot, but they were important witnesses that they were trying to tell the judge, can we just ask our questions outside the scope of direct examination on cross that we were going to ask them on our case? Can we just do it now, save everybody time? They weren't trying to save time. They knew they weren't going to bring a case to begin with. So if they can let the judge, who tends to be more lenient towards the defense to prevent appellate issues, can we just squeeze in a few more questions that weren't asked on direct? That is strategy. That way they don't have to call anybody else out. And it worked twice. Carmen got called back so that the defense could have an expanded cross-examination. And then Allie fully got to have the defenses direct in their cross. And this is also why they made crazy big whoops. You're not letting us impeach. You're not letting us do the cross right. Because they never planned on bringing anybody back. Oh, and Bloodworth said in Biggin, law nerd.